Welcome back to This Day Live, the Sunday talk show here on the Arise News channel. With me today, I have Professor David Awurawo, Professor of International Relations and Strategic Studies at the University of Lagos, and Jide Ologun, legal practitioner and national development advocate. 12 years after Nigeria last had a female Chief Justice, Justice Kekere-Ekun has made history after being sworn in as the acting Chief Justice of Nigeria. President Bola Tinubu praised Justice Kekere-Ekun for her exceptional service and called on her to uphold the judiciary's independence and integrity. Arise correspondent Adesua Omorwan reports.
I, Kudirat Otomori Olatokunbo Kekere-Ekun, do solemnly swear that I will be faithful and bear true allegiance to the Federal Republic of Nigeria.
The swearing-in ceremony at the presidential villa saw the presence of family, colleagues, and key government officials, including Supreme Court justices, the former Chief Justice, the head of courts, President of the Nigerian Senate, Governor of Lagos State, and other top government officials. Justice Kudirat Kekere-Ekun is sworn in to succeed Justice Kayode Ariwoola, who recently retired. Following the oath taking, Justice Kekere-Ekun took her place in the council chambers. President Bola Tinubu, who returned from an overseas trip for the event, underscores the judiciary's vital role in Nigeria's democracy. He urges Kekere-Ekun to uphold the constitution and defend judicial independence, while describing her as an inspiration for young women aiming to break barriers.
I dare for all your lordship to be faithful and loyal to the Constitution when discharging your duty as acting Chief Justice of Nigeria. I also encourage you to defend the judiciary's independence, always promote the course of justice, strengthen mechanisms for integrity, discipline, and transparency in the judicial sector, and pursue other reforms or initiatives to sustain public confidence in the judiciary.
The president also reiterated his administration's support for the judiciary.
Let me also reassure you that the judiciary under this administration will continue to receive prompt and adequate attention in recognizing its status as a driver of social order, rule of law, peace, security, and economic development.
Pending Senate confirmation, Kekere-Ekun will become Nigeria's 23rd Chief Justice. Her appointment signals a new era for the judiciary, with high expectations for her tenure.
Whatever the shortcomings that we see today, we're all members of the society. So if we want to see improvement, let the improvement start with each and every one of us and our approach to justice. Let us all also have faith in the system, and then we'll also be more particular about the process of appointment. I know it gives a lot of concern, discipline on the bench, at the bar as well. All these things are aspects that we will look into. And I believe that by the grace of God, at the end of my tenure, we will have a judiciary we can all be proud of.
The Lagos State Governor praises the smooth transition and the president's swift appointment of an acting Chief Justice.
Within 24 hours, we've seen the beauty of our democracy. Mr. President himself had to stop his own trip to ensure that, governance and democracy does not stop. There's no vacuum. We're excited not just because she's a Lagosian, I am, but because of who she is. She's been an outstanding jurist, and from her resume, she's one of the only very few people that started first, just as the lawyer, and also passing through all of the various courts.
Justice Kudirat Kekere-Ekun, called to the bar in 1981, is the second woman to hold this role, following Justice Mariam Aloma Mukhtar. Her efforts to enhance the judiciary's reputation and public confidence will be keenly watched. Well, the president also used the occasion to thank Justice Kekere-Ekun for his service to the judiciary and the nation for the last 33 years. From the presidential villa, Adesoa Omoruan, Arise News.
Public interest lawyer and human rights advocate Effiong joins me now for his perspective on the change of guards at the Supreme Court, the emergence of the new Chief Justice of Nigeria, and the task before the new CJN. Good to see you, Effiong. Thank you for joining me on This Day Live, the Sunday talk show.
Thank you for having me. Good afternoon, Dr. Bati.
Yes, very good to see you. Well, first of all, let me congratulate Justice Kekere-Ekun, the family of Pa Fasinro of Lagos, the Lagos State people, the gender to which she belongs, and her family on this elevation to the topmost position in the Apex Court. But let's deal with the issues before us, beyond the congratulations. The first is, let's start with a review of the tenure of Justice Olukayode Ariwola, who ended his tenure. You know, it was a very controversial tenure. A lot of people saying, oh, he didn't do this, he didn't do that. He didn't address Justice Datijo Mohammed's, valedictory speech and the issues raised in that speech. What do you think of the tenure of Justice Olukayode Ariwola, the 22nd CJN of Nigeria?
Thank you. I think for many legal practitioners in Nigeria, the tenure of my Lord, the just retired Honorable Chief Justice of Nigeria, to some extent, or to a large extent, was trailed by controversies. Some of these controversies were, in some sense, self-inflicted. Some of the controversies were external to the judiciary, but the judiciary, under my Lord's leadership, struggled to curtail the impact of those controversies. For example, when you listen, like you have cited, the valedictory speech delivered by the retired Justice of the Supreme Court, that is Mohammed, you would have noted some of the complaints, some of the internal issues in the Supreme Court itself, where the welfare of justices were not properly addressed, where issues regarding vacancy in the Supreme Court were addressed, were raised at that valedictory session. And then there were also generally issues about the loss of confidence of Nigerians to some extent, not entirely, but to some extent, in the manner that the Supreme Court handled certain cases. It was under my Lord, Justice Ariwola, that the controversial judgment that made Akpabio the Senate President today was delivered, that Lawan today is a member of the Senate. These are individuals who did not participate in the primaries of the APC, but today they pride themselves as senators or distinguished senators in quotes of the Federal Republic of Nigeria. It was also under my Lord Justice Ariwola that the controversial Imo Supreme Court judgment that brought Hobu Zodima to power was delivered. And it was also under my Lord, the Honorable Justice Ariwola, that judicial appointment became very hotly contested. And, very strong allegations were made regarding allegations bordering on nepotism and so on. And many people believe that these questions were not satisfactorily answered. But again, what is important for me as a Nigerian first, because you have to be a Nigerian, for you to be a Nigerian lawyer, is to see how to move forward. I listened to the comments of my Lord, the Honorable Justice Kekere-Ekun, the acting CJN, who in making a speech after she was sworn in as acting Chief Justice of Nigeria by the President, my Lord indicated that the priorities of my Lord's leadership, one of it would be to restore public confidence in the judiciary. For me, that is the most important thing. We have to be honest with ourselves as a profession that Nigerians, the confidence of Nigerians in the judiciary has eroded over time. There is no doubt about that. A clear instance is in political matters, election petitions, and pre-election matters. There is a school of thought now that to some extent the Supreme Court is being perceived, as a court of affirmation. Whatever politicians do, they can kill, they can manipulate, they can sabotage the process, and they can bastardize their internal guidelines that is mandated by the Constitution. They can set aside all the principles of democratic elections. Once they have made an announcement, people just believe Supreme Court will affirm it. Sometimes this is based on inability of petitioners to prove their case, but I'm just telling you what the perception is, that there are those who hold the view that the Supreme Court needs to do more to regain public trust in the adjudicatory role of the Supreme Court in an election petition. I, as a person, I have always been fascinated by the role of our courts in our election process. That was why, even as an undergraduate, when I was leaving the university and I had to choose a project topic, my topic was issues and challenges in the adjudication of election petitions and the future of democracy in Nigeria. Okay. And what I found in the course of that academic research was that over the years, the ability of the courts to adjudicate and resolve election petitions seems to have whittled down. It appears that the courts now, to a large extent, electoral justice is more or less becoming a very scarce commodity in our courts. Okay. But this is due to many factors. The point I am making is that, Dr. Bati, the point I am making is that the task before the acting CJN, right, and expectedly when my Lord is confirmed, the substantive CJN, is to find a way to begin to restore public confidence, not just in political cases, but generally in the justice system. Okay, yes. Inibe, I hear you very clearly. We'll come to that point about the agenda for Justice Kekere-Ekun. If you check this day newspaper today, this day on Sunday, it's the front page of the newspaper, people setting agenda for her and people raising issues, including restoring confidence and a number of things that should be done. But do you think there is an issue that a Yoruba CJN is being succeeded by another Yoruba CJN? Do you think that's an issue in terms of how persons are elevated to the apex court? That's the topmost position. Completely irrelevant. It is a non-issue. It is not an issue. It doesn't exist. And anyone who is parroting that kind of opinion should be enlightened. It might be due to lack of information. It must be stated that assumption of office as Chief Justice of Nigeria or even Chief Judge of a state or President of the Court of Appeal is based on seniority, right? You don't just become CJN. And let me also use this opportunity to say clearly that President Tinubu is not doing my Lord a favor. Because I see people people mischievously thanking the president for appointing. It is automatic. It is based on seniority. It is based on seniority. It's based on hierarchy. From when you are appointed as the Justice of the Supreme Court, you take your line. The line of succession at the Supreme Court is based on seniority. Okay. So the fact that we have a former, the immediate past CJN is Yoruba, and the new acting CJN is completely irrelevant. Okay, these are positions that my Lord, the Honorable acting CJN has earned. What do you think of the argument, which has been on the table since the time of Justice Dairu Mustafa, that look, appointment to the position of the CJN does not necessarily have to come from within, the seniority line that you have talked about. That in fact, the CJN of Nigeria, the Chief Justice of Nigeria, can be appointed from outside, the judiciary. What do you think of that argument? Even the same argument has been made
for, appointment of, elevation of senior advocates of Nigeria. Do you think that the pattern that we follow, it looks like just a closed arrangement? After all, Justice Teslim Elias came from academia to be Chief Justice of Nigeria.
Well, if you look at section 230 and 231 of the Constitution and other relevant constitutional provisions, there is some constitutional merit to that argument. The Constitution does not say that for you, let me even start from the basis. The Constitution does not say that for you to be elevated to the appellate court, that is, say that for you to be a judicial officer, an appellate judicial officer, a justice of the Court of Appeal, that you must have been a judge of the Federal High Court or a state high court. It is not a constitutional requirement. Similarly, the Constitution also does not say that for you to be appointed a justice of the Supreme Court, you must have been a justice of the Court of Appeal. What we have now is basically tradition that has been given, some sting, some judicial teeth or some legal teeth. It has not become like a law. But by the Constitution, it is not that for you to become the justice of the Supreme Court, therefore you must have been in the Court of Appeal, because that is where you have to start from. It's not just by jumping to the CJN. But the way it has been, the way the NJC has made it now, that is the National Judicial Council and the Federal Judicial Service Commission. Appointment is now basically to appellate courts is based on elevation. So you would hardly find in fact, you will not find a justice of the Court of Appeal today who is not coming from the Federal High Court or from the State High Court or from the National Industrial Court. So I would be open. I'm very open to having reform that may accommodate having practitioners who are appointed directly from practice to the appellate court. I don't think there is any harm in that. But regarding the position of CJN, it might be difficult. I'm not saying I'm opposed to it. I'm just saying that it might be difficult. Because if you're appointing, say, a legal practitioner or a senior advocate of Nigeria to become a justice, first has to be justice of the Supreme Court, or even directly to be Chief Justice of Nigeria, what happens to the justices of the Supreme Court who have been in the apex court over the years? That can create some bad blood. I know that people are naturally resistant to change. But again, I am open to a reform, an argument on reform. I'm just making the point that if you are going to have that kind of radical change in the qualification, if you are going to interpret the Constitution the way it is, and then want to test the waters, it will be difficult because already this tradition has been entrenched. So if we have to embrace that, let us start by appointing to the court before we go to head of courts, right? Before you can appoint a senior advocate of Nigeria or a lawyer to directly become Chief Justice of Nigeria on the basis of his or her age of call or post-call experience at the bar, make a Justice of the Supreme Court to be a person who is not a Justice of the Court of Appeal. Okay. When you succeed in that, we can see how that experiment works. Okay. But to now say you want to appoint a lawyer directly to become CJN is going to be very difficult.
Okay, Inibe, I get your argument. But before I talk about the agenda for Justice Kekere-Ekun, which is, a subject that is already up here, hanging in the air, which is also an important subject. You talked about Justice Ariwola in terms of the controversies. And there are civil society organizations, concerned lawyers, doing a review of his tenure. But will you agree that, in fact, under him, he was able to put behind him, in terms of legacy, a number of achievements. One, he was able to establish the full complement of the Supreme Court, 21 justices, for the first time in a long time. Two, under Justice Ariwola, we had increase in the retirement age of judges at the level of the High Court and also at the level of the Industrial Court, creating a certain kind of equilibrium within the system. It was also under his watch that we had this local government financial autonomy becoming a matter of law and all of that. Okay, don't let me list all his achievements, but these are the key principal ones. But you focused only on the controversy about election matters adjudication. Will you agree that, part of his legacy are some of these things that I've listed?
Of course. I mean, these are facts that you have enumerated. we cannot say that the tenure of the former CJN was not entirely embroiled in controversies and there were no, things or achievements that can be credited to him. That would be very unfair. That would be really unfair. So there are things that were done that is, attainments under the tenure of the former CJN that can properly be credited to him. The point I made is that if you are going to restore the confidence of Nigerians in the judiciary, you must start with the things that really, really touch, that are the heart of the institution of the judiciary. One is independence of the institution. Nigerians must believe that truly the judiciary is independent. Because I must say, I must say it clearly, with all sense of humility, that today, my personal opinion is that I feel that the executive arm of government is too comfortable with the judiciary. It is looking as if members of the executive have basically gone to sleep, right? There seems to be, this perception that the executive can do whatever it wants to do and get away with it. That is why it is not a surprise that we are seeing arbitrary arrests of Nigerians, of activists, of journalists. We are seeing increase in actions that tend to show descent into dictatorship. That is partly because people believe that the role of the judiciary as the guardian of our democracy has been eroded to a large extent. So if you are going to restore public trust in the justice system, we must address the issue of the loss of confidence, right? But regarding those institutional reforms that you have mentioned, they are commendable. But I'm saying you must go beyond that. You must go beyond that. You must look at the issues Nigerians, because what is the judiciary meant for? It is an arm of government that is meant to serve the Nigerian people, just like the other arms of government. But guess what? Why this is important is that, unlike the legislature, unlike the executive, the judiciary is the sole institution that has the constitutional power to resolve disputes, not only between arms of government, but even dispute within the judiciary. So if there is a dispute within the judiciary, it is still the judiciary that will resolve it. If the executive and the legislature are fighting, they still submit to the court. What that shows is the unique and what is supposed to be the sacred position of our courts. And that is why judges must live above board. That is why judges must not be equated with politics and politicians. That is why where they stand have to be one that cannot be questioned.
I get your point. The big challenge is how to remove politics from the performance of the judiciary. You are saying invariably, as many people claim, that the judiciary has been politicized. It's too close to the executive. But as for Justice Ariwola, who is now retired CJN, it was under him that salaries of judicial officers went up by 300%. So in terms of taking stock of what he has done. Now, let's talk about my Lord Justice Kekere-Ekun. I referred earlier to the front page of this day newspaper. Olanipekun SAN says there is a need for rethinking, repositioning, restoration, rebandering, and rejigging of the judiciary. Agbakoba SAN says that the new CJN has to turn around the model of the court. Dowdy SAN says the incoming CJN should push for the creation of constitutional courts at 3 tiers, trial, appellate, and final, for the determination of political and other allied matters. Yadudu says she should ensure that bad eggs in the judiciary are not treated with levity or a mere backslap. Idigbe SAN says she must be courageous to resist skeptics and defend against internal and external pressures. Front page, this is a newspaper of Sunday, August 25. But you are saying, primarily, she has to restore confidence. Some people say, oh, she has to introduce technology. Justice Ariwola, in his valedictory speech, says, look, the backlog of cases will need to be cleared because the Supreme Court is overburdened. Now, in specific terms, what will be your own prescribed agenda for the new CJN?
I think for me, the starting point has to be on discipline for members of the profession. We must find a way to reform the NJC. And I want to plead with my Lord, the acting CJN, and I believe my Lord is going to be confirmed, that my Lord is having a conversation with history. Being the second woman in the history of our country to be the head of the Nigerian judiciary. When the retired Honorable Justice Mariam Mokhtar was CJN, Nigerians saw, if you ask legal practitioners, they will tell you that that was one of the best judicial tenures. That was one of the best dispensations of a Chief Justice of Nigeria. So the first time we had a female CJN, the judiciary to a large extent was highly respected. My Lord Justice Mariam Mokhtar excelled, and many of us had cause to commend her for her courage, for her discipline. So what I am saying is that this is a unique opportunity for my Lord not only to speak in having this conversation with history, not only to speak to the date of our swearing in, to the date of our assumption of office, but also to the date that my Lord will retire. Because the day is going to come, Dr. Bati, that a valedictory session will be held for my Lord, the Honorable Justice Kekere-Ekun. And the same manner we are reviewing the legacy and the tenure of my Lord, the retired CJN, Ariwola today, is the same way that we are going to review, that Nigerians will review, that history will review the tenure of my Lord, Honorable Justice Kekere-Ekun. So my Lord must have the courage, and I pray for my Lord to have the courage to reform the judiciary. Because courage is required. So much water has gone under the bridge. There is so much problem with the institution. And you cannot solve a problem that you have not identified. You cannot solve a problem that you are not ready to admit that it exists. My Lord must start with discipline. Dr. Bati, you are aware. My own travels with the judiciary in 2022. Part of the problem then was that I had an issue where a chief judge was telling me, go to the NJC. At every opportunity, I was being taunted to go to the NJC. There is nothing you can do, go to the NJC. Because the perception is that nothing will happen. And this is not personal to me. You speak to people that have grievances, they just simply tell you that you are wasting your time. So I don't want this perception to remain. I want this perception to change. That is why I am pleading with my Lord. Please listen to what history is saying. And please remember that one day a valedictory session will come. And Nigerians will ask, what was achieved? I know that my Lord has this opportunity to make history. The other aspect is appointment. The other recommendation is judicial appointment. Who is eligible to become a judge of the Federal High Court, of the FCT High Court, of the Court of Appeal, or a justice of the Supreme Court? We must find a way to live by the admonition of the Supreme Court in the case of Odedo and INEC, that judges must stay away from politics and politicians. Nigerian politicians are doing everything possible to subjugate the judiciary, to capture the judiciary, to appoint their stooges into the judiciary. My Lord must have the courage to ensure that judicial appointment is based strictly on merit. This perception that it is hereditary, you must be related to somebody in the bench, or you must have a godfather, and we see even members of the bench talk about these things. I hope that my Lord will have the courage to reform the process of appointments. Let it become strictly merit-based. Let it be transparent. When judicial appointments are made, it is now becoming like a lifestyle. Every time a judge is appointed, we see controversy. People begin to look at who is this judge related to. Who is the godfather? Who is the sibling? So this is not how it is supposed to be. That has to change. Okay. Also, conflicting judgments, conflicting decisions of courts. My Lord must find a way to put an end to it. You cannot have a situation where two courts of coordinate jurisdiction will be giving conflicting judgment on one subject. Look at the embarrassment in Kano, where you had the Kano State High Court, the Federal High Court Division in Kano, saying different things about who is the Emir of Kano. We cannot have that. In election matters, it is even worse. It is even worse that we get conflicting judgments. This has to stop. An end must be put to this. Dr. Bati, one other point I want to emphasize. The judiciary must assume its position as the guardian of the Constitution. There is so much impunity today in our country. Organs of the executive have come completely lawless. They have run amok. The SSS cannot be checkmated. The police cannot be checkmated. No institution of the executive today can be held accountable. The judiciary must have the courage to put an end to illegal arrest and detention of Nigerians, to arbitrary issuance of remand orders. We are seeing some orders recently being given by our courts, and Nigerians are beginning to ask, where is this coming from? So I'm saying that my Lord must have the courage. This is not a problem that is general to the judiciary. But the problem with the judiciary, unlike the other arms of government, is that one decision, Dr. Bati, one judgment, one ruling can cast aspersion on the integrity of our courts. Most of our justices and judges, they want to do the right thing. But sometimes they are impeded by the system. Did we not see the agents of the executive invade our courts? Dr. Bati, what was the rebuke from the judiciary? What happened? The judiciary must begin to protect its independence, its sanctity. You cannot be having law enforcement agencies breaching into the hallowed chambers of our courts to arrest people. We cannot be having a situation where judges will give restraining order that Nigerians should not be arrested illegally, and the police and the SSS and the military will violate it, and there is no consequence. The judiciary, judges in Nigeria must begin to assert the authority, and that must start from the CJN. It will take the CJN to give the leadership for this to happen.
I get your point about conversation with history, judicial courage, independence of the judiciary, and all of that. But let's take a look at the record of Justice Kekere-Ekun on the bench. I think in 2016, she was one of those justices who affirmed the victory of Nyesom Wike as governor of Rivers State, after the tribunal and the Court of Appeal had thrown away the case. In 2020, she was one of the justices who again affirmed former Governor Gboyega Oyinlola as governor of Osun State against Ademola Adeleke. In the case of Kogi State, APC James Faleke case, she was also one of the justices who kept Yahaya Bello in the position. And then in Imo, the Opuzodinma case, how number 4 became 1. She, in fact, read the lead judgment. Now, in the American jurisdiction, judges are, justices are assessed on the basis of their ideological leaning. So what does this tell you about what we should expect in terms of judicial independence? You used that phrase, and I throw it back at you.
Dr. Batsi, I did not see so much of military regimes in Nigeria. I was still a bit young as a child, but I saw a bit of military, but I was much young. Today, under democratic dispensation, when I read law reports, when I see judgments of Supreme Court that were given under the military, today every student of law, year 1 law student, will tell you, oh, military governor of Lagos State and Odumeko Jugu. What happened? The Supreme Court stood up to executive impunity. The Supreme Court looked the military in the eye and said, no, you cannot do it, and rebuked it.
Yeah,
you cannot take Ojuku's property.
That was a golden
when there's
season.
Another, of course.
That was the golden season of the Supreme Court.
The golden era of the Supreme Court.
Yes, when you had
Dr. Bati, Guardian newspapers of Nigeria, and Attorney General of the Federation.
Yes.
Yes.
Go ahead.
Yes.
Go ahead.
The case of Guardian newspapers. Same Supreme Court of Nigeria. Fahmi and Akilo on the killing of Delegiwa. Same Supreme Court of Nigeria. I can go on and on. These were decisions given. Even when AK-47 was figuratively pointed at the justices, they still stood by their judicial oaths. They dispensed justice without fear of favor. And to a large extent, they preserved the honor, the integrity, the independence of the judiciary. So more is expected under our supposed democratic or constitutional dispensation. What is the point? You remember I said that even as an undergraduate, I have always been fascinated by our electoral jurisprudence. But I did extensive research. I had to review so many judgments of the Supreme Court on election petitions. And I realized that today, Dr. Bati, I am forced to tell you, I just have to confess to you, it is very hard, if not impossible, for a petitioner to have his case proven in our courts. No matter how fraudulent, no matter how violent, no matter how sinister, no matter how lawless INEC or the politicians or the political parties are, it appears that the jurisprudence today favors that once declaration is made by INEC, that is the end of the matter. Because of precedents. Precedents. Right? So I'm not saying that, look, some of these things require legislative interventions. But there are also aspects that the courts can change. Holding INEC accountable. I personally, I am not happy that INEC violated its guidelines and continues to do so till date. And we don't seem to get strong rebuke from our courts. Even if the Supreme Court says that the Constitution and Electoral Act did not make the use of IREF mandatory, for the fact that public funds, Dr. Bati, billions of naira, was used for this purpose, there was a guideline backing it, INEC promised to do it, they went to court, no satisfactory explanation, the court should have rebuked them. The court should have chastised them. So I am pleading with the Supreme Court, please, listen to what Nigerians are saying. Otherwise, the day will come that people won't even go out to vote again. I mean, look at the charade that happened in Kogi recently in the name of governorship election. All of us know there was, I mean, we saw what happened in Kogi. We saw it. Nigerians, even in Imo, all the splinter elections that are taking place, Nigerians are not blind. We can see, we can hear. But at the end of the day, it is almost impossible to prove your case. Right? Some of these precedents, my lords, the Supreme Court must find a way to maybe look at them again. That is it really advancing our democracy, or is it emboldening impunity? Politicians are now more emboldened than before. In 2015, some of the gains that were made, it has gotten worse now. Even with the new Electoral Act, Dr. Bati, we seem to be going backward. So I'm not saying that the courts are to blame. I'm just saying that the courts can help the situation. Because, yes, decisions of course should not be premised on sentiment or emotion or public expectation. No. But eventually, the courts are serving the nation. The Supreme Court is also a court of policy. So some of these precedents, some of these electoral decisions, they may be need to look at them again.
Okay.
They may need to look at them again. For example, let me give you an example. The Supreme Court has ruled, right, in the case of Obi and Tinubu, Atiku and Tinubu, that when you are filing your petition, you have to front-load the statement on oath of witnesses on subpoena. Dr. Bati, what that means is that if you want to compel INEC to tender a document or to give evidence or want to call NYSC to prove that someone has forged a certificate, you must be able to procure the evidence of that witness from that agency before you file your petition. Dr. Bati, in which world is that possible? You have 21 days.
Okay.
Dr. Bati, I had the misfortune of representing a petitioner. Please let me say this. A petitioner in the last election. Dr. Bati, I've got an order from the tribunal in Akwa Ibom in the central petition to compel INEC to give us materials. Dr. Bati, INEC did not comply with some of the documents we wanted. What could we do? We wrote to the chairman of INEC, no response. We wrote to the lawyers representing INEC, no response. At the end of the day, you have 21 days to file your petition. Okay. When you let her get the documents, it is useless to you.
Okay.
So we need to review the jurisprudence on the election. If this democracy must survive,
I get your point.
The jurisprudence, or our electoral jurisprudence, we must look at it again.
Okay, Inibe, I get your point. Electoral reform, judicial reform, judicial independence, judicial courage, and Justice Kekere-Ekun has the next 4 years. She's 66 now. She'll be 70 in 4 years' time. Plenty of time to do a lot. And Agbakoba says, well, maybe she should take another look at the reforms proposed by Justice Mustafa, and some other people say by Justice Dachijo Mohammed. She has her work cut out for her. We'll be here. We'll be watching. Thank you very much for joining us on This Day Live, this Sunday talk show.